about the constituent power and the basic structure of the Constitution. And here you recall the question that was posed by Justice Kiaga to Senior Counsel George Oraro. Can the people of Kenya, through their majority, resolve to remove or abrogate Parliament? What was his answer? He said yes. Permit me to take you back in history. When is the pivotal moment in the history of the world when this was attempted? It was in 1933 by Adolf Hitler. And history records that of all the European leaders of that time, it is only Adolf Hitler who ascended to power with an overwhelming majority at the ballot. Now, let's see what Justice Errol Regera said about that issue. He proceeds. In my judgment, the framers of the Constitution could not have contemplated or intended such an absurdity, the removal of Parliament. And it will not be an answer to that concern to say, as was said by counsel for the second respondent, that the people can't change their Parliament. It is as simple as that. Now, let's domicile the basic structure in text. And I will take you back to Professor Nubweze writing about presidentialism in Commonwealth Africa, and still on the topic of the constituent power. And permit me to emphasize, when Nubweze writes, it is not a suggestion, it's not a concept. He indicates what the law is. And for those without the benefit of good learning, this is the point. If you go to your library, you will find the common law texts. For instance, we have Chiti on contract. Chiti writes the law. We have the Smith on constitutionalism. The Smith writes the law. We have Gower on company law. They write the law. So that when we find these postulations in the written works, they're not suggestions. They are the law. Now, we go back to page 496, where Nubweze talks about the basic structure. And in particular, you'll find this at page 500 to 501. 500 to 501. So we start with page 500 at the bottom where it starts as follows. amendment, in fact, established a new constitution, and as such, should have been effected by the repeal of the existing independence constitution. He says this in 1973. Is he alone when he says this? No, he's not alone. He is joined by Justice Aaron Ringera many years later. And this is what Justice Aaron Ringera said, commencing from page 688 at the last paragraph. Before I leave this aspect of the matter, let me comment on the previous amendments to the Constitution of Kenya.
Now, what the law requires is that the person appending the signature, which is delivered together with a draft bill and called supporting signatures under Article 257(4), be registered voters. And so the Commission needs to undertake a process where it confirms whether what it has received as supporting signatures from the promoters are indeed signatures of registered voters. And our submission humbly is that if what the drafters of the Constitution intended was that the verification simply be that this name appears in the register of voters, it would have asked for a list of names of voters. It would not have asked for signatures. And indeed, my Lord Justice Kiage did ask what my senior counsel, Professor Gideon Megayo, was it? I think Senior Counsel Tenda Molo was referring to as a unique identifier. How would the IEBC know that that name, for instance, belongs to Esther Angawa, who has appended her signature in support of the bill? And Senior Eric Gumbo read to the court the definition of biometric data, which is what our law identifies in elections law as the unique identifier, biometric, defined as unique identifiers or attributes, including fingerprints, hand geometry, earlobe geometry, retina and iris patterns, voice waves, DNA, and signatures. Of all the unique identifiers that would identify Esther Angawa to the Commission, it is only signatures that appears in 257(4) as a requirement to be handed to the Commission. It must be verified that those signatures belong to the people they are claimed to belong to. And it has been considered that there is no framework for such. In fact, Senior Gumbo went ahead as to say that to demand, he said that the court, the command of the court, and Senior Gumbo, if it wasn't you, please forgive me, it could have been any of the counsel for the appellants, my lords and my ladies. The submission was made that that command came from the High Court. It was not a command by the High Court. It is a command of the Constitution, Article 257(4) demands that. The appellants took umbrage with the fact that the Superior Court referred to its treatment of verification of signatures in the Okoa Kenya initiative, and more particularly, that the High Court found it startling that the Commission was taking a completely different approach in this case on what it meant for them to verify signatures. My Lord, we urge this court to uphold the finding of the High Court on this question, and we urge you to be persuaded by what this court held in James Omingo Magara and Manson Onyongo Nyamweya and two others, versus Manson Onyongo Nyamweya and two others, 2010. It's at volume 1, page 187 to 210. The particular paragraph being at 199. And this is what the court said, that the verification of voters, in this case, and I'm sure, my lord, the presiding judge are well aware, this being an appeal against your decision when you were a judge of the High Court. And the argument was that the verification of voters is simply a matter of math, or the votes that were attained. And this court held that verification of voters or votes is not a basic exercise, but a matter that requires beyond simple arithmetic ascertainment. The commission submitted here that they ran the names through a program, the names. That is how they verified that the signatures they had received belonged to registered voters. And they attained the number 1 million, and that was enough. We humbly submit that the yardstick applied by this court in Omingo Magara must be the same yardstick, if not higher, for the verification of supporters of a popular initiative. Before I move to the next issue, my lord.
So in precise terms,
yes.
How should that look like? How should that be done?
My lord, let me begin by expressing my surprise that the commission can come and state that it does not have signatures or unique identifiers of voters in this country, especially because we have a biometric system of voter registration. We have a biometric system of voter registration, and one of the unique identifiers under the Act are signatures. It is incumbent upon the Commission, and more particularly because of the fact that taxpayers pay for the work of the Commission. Taxpayers pay for the biometric voter registration. It cannot lie in the Commission to come and admit that it does not have that which it says in the Act is a unique identifier when we have a biometric voter registration system.
So I understand you to then be saying that the Commission should then look at each signature, each signature of the 1 million, and then check that database and satisfy itself that each signature corresponds with that one.
Absolutely, my lord.
If I could just follow, are you suggesting that registered voters who do not have signatures cannot participate, cannot be the support an initiative under Sabbatical 1 to make up the 1 million, so that those who do not have signatures cannot participate?
My lord, it is not my suggestion. The Constitution demands that what is presented to the Commission are supporting signatures. If I do not have a signature as a voter, how would my signature end up in the list of supporting signatures to the popular initiative? Unless I'm not understanding your flow, my lord. You seem to ask what would happen to those without signatures, but the Constitution demands for supporting signatures. So if I do not have a signature, what will I be appending on to that supporting document?
What is the definition of a signature in law? You remember that in the Stanley Ngindo Matiba case versus Moi, that issue arose whether the petitioner who could not sign because he was paralyzed, whether he could present a petition. You remember that? Mm-hmm. So the question is, a signature is required. What is a signature in law?
My Lord, I could write my name. It could be a scribble. It could be a thumbprint, if that is how that is what I have indicated to the Commission, is what identifies me as that voter. When you retire, my lords, please do consider Volume 1, page 343 to 361. Professor Albert Stam on methods of state constitutional reform addresses the same issue, more particularly at paragraph 347. Now, my Lord, before I move to voter registration, I think it is important that we look at the arguments given by the Commission for not being in a position to do what is demanded of it for lack of quorum. And particularly, my Lord, because this bill, the bill that was impugned by the Superior Court, is said to be an initiative of the people. And the Commission has come and said that even though it doesn't have quorum, it can still create the administrative procedures for this process, and the court should indulge it, because the question of the membership of the Commission is not its fault. And I believe, my Lord, you asked me, what if these things happening are not of the fault of the Commission? And my Lord, it is important to know that in Isaiah v. Watt, the judge said that he decried the late recruitment of commissioners, this lack of quorum being due to resignations. And I think it is important, my Lord, for us, just before I move from that point, so that we can understand what the court is being asked to do here when it is asked to overturn the findings of the High Court. The Commission, which concedes it has only 3 commissioners, is here saying it can still proceed to do what it needs to do despite the diminished membership. The Attorney General, who is the advisor of government, including the Commission, is also here saying the same thing. Let's overlook that issue because it's not the Commission's fault. The President, upon whom the responsibility to declare vacancies in the Commission is placed by Section 7 of the IEBC Act, is also here. Parliament, whose work is to oversight the executive, is also here, telling us to ignore the fact that there have been vacancies in the Commission for more than 3 years and allow them to rely on their administrative procedures, which the Commission conceded was supposed to be an internal issue and only came out because somebody wrote a letter asking, how are you going to do this verification? Never once has the Commission, unless, because it hasn't made any submissions to that effect, stated what handicap there has been, why there has been no recruitment. Not once, not before the Superior Court, and not here. Their submissions were purely ignore, we can still operate. In the country that we live in, my lords, it is important that we take notice of all those in power who ought to do their work within the precincts of the Constitution and fail to do so, but come here and expect the court to ignore all of that and assist them to continue down that road. Voter registration, my lord, paragraph 764 to 772 of the judgment deals with the issue of voter registration. Our submissions on this are very brief, my lord. Article 38, 3A and B of the Constitution gives any eligible Kenyan the right to vote. Article 82, 1C of the Constitution demands that voter registration be continuous. The Commission has submitted that voter registration has been continuous. Notwithstanding that the Gazette notice filed indicates that that is data as at 2019, 31st of December. My lord, young men and young women are still turning 18 after 31st of December 2019. Old men, young women, middle-aged are still dying after 2019, 31st of December. And the law demands, the Constitution demands voter registration be continuous. The Elections Act, and the Commission read this to us yesterday, Elections Act, Section 5, subsection 1, provides that in compliance with the Constitution, registration of voters and the revision of the register of voters under this Act shall be carried out at all times. Before I move to the except, my lord, we submit that there has been no evidence, not before the Superior Court and not before this court, that voter registration is going on or has gone on beyond the 2019, 31st of December.
I thought you were referred to an affidavit of Mr. Agoa, where he deposed inter alia that there has been continuous registration, or you say that is not the case?
That affidavit, my lord, is it the affidavit that was introduced in reply to the
No, there was an affidavit. There was an affidavit that was filed in the High Court.
My lord, that affidavit did not provide actual data or information about evidence. I can come here and say that I have been reading 10 judgments a day as proposed by one of our seniors, Steve Ogola, but nobody can establish whether indeed I have been reading 10 judgments a day. Now, I would be more convinced by the Gazette notice that was brought into this court indicating the numbers of registered voters as at that time. And my lord, it is a matter of public notoriety, really, that there has been no voter registration.
All right, please move on.
My lord, the appellants have an issue and seek that this court overturns the finding of the High Court that no referendum should take place until there has been mass voter registration, nationwide voter registration. And they say so, this was their submission yesterday, that before the IEBC receives the notice or receives the bill from the president, that issue is not right. That was their submission. That they cannot begin voter registration en masse before they receive that notification and actually know that there is going to be a referendum. But what does 5(1)(a), 1(b)(a) say, my lord? Registration of voters and revision of the register of voters under this act shall be carried out at all times except, when you go to BA, in the case of a referendum, between the date of the publication and the date of the referendum. Move with me, my lords, to section 49 of the same Elections Act, part 5 on referendum. And this is what it says at 49(6). Here I am assuming, my lords, I'm going with the argument that the commission made that these provisions are sufficient for governing the referendum, whether it be a constitutional referendum or an issue-based referendum. So move with me with that, and let's assume that we will apply these provisions to the constitutional amendment bill. And this is what it says: the commission shall conduct the referendum within 90 days of the publication of the question. Now, if the commission is to conduct a referendum within 90 days of the publication of the question, and 5(1)(b)(a) states that no registration of voters can take place once the publication for the referendum is done, when really does the IEBC want all these Kenyans who are eligible to be registered as voters to be registered? What faults do they find in that holding by the High Court, that they must undertake voter registration before a referendum? They are saying they can only do that after they receive that bill from the president. Yet the very provisions that they wish to rely on, should there be need for a referendum, provide a 90-day timeline and the date of publication. It cannot be, my lord. That ground must fall. Public participation. The IEBC, among the other appellants, insisted that it is the plebiscite where the people participate. That is the heart of public participation in a popular initiative. We submit, my lord, and I will not extensively submit on what John Locke and Montesquieu provide in the Two Treaties and the Spirit of Laws, Volume 1, page 240 to 296 and 339. It is our submission, my Lord, that public participation is an incidence of the social contract, and it need not be textualized under 257 for it to be effectuated, or for the right to inhere upon the people. And my Lord, it is important that we look at the JLAC report and what it said about public participation. Volume 4 at page 1375 to 1559. That's the entire report. But on the question of public participation, this was the recommendation at paragraph 409 of the report at page 1495.
Yes.
I'll read it, my Lord. 409. There was need for Parliament to put in place a legislative framework on public participation at both the national and county levels of government.
Where are you, Council?
This is volume 4.
You say page 409,
14, paragraph 409 of the report, but page 1495. 1495.
Yes. Please go on.
The Houses, further, in the absence of specific provisions under Article 257 of the Constitution, provisions should be included in the proposed law or in the standing orders of the Houses to provide for public participation in the processing of a constitutional amendment bill by popular initiative.
Yes.
My Lord, we move on to publication of that bill. Page 1501 at paragraph 437. It was observed that in order to avoid any question arising on the authenticity of a bill for an amendment of the Constitution by popular initiative during the processing of the bill at the various stages, a legislative framework ought to be provided for the publication of the bill. Paragraph 437, page 1501. My Lord, an amendment proposal through the parliamentary initiative cannot be placed before the House